Shout out to ASAP Rocky. In case you missed it, we've got to run this video back one more time before we get into talking about the civil lawsuits, a couple civil lawsuits that ASAP Rocky is looking at facing from ASAP Relli and what that means for him moving forward. We got to run back the victory footage from last night's verdict. Here we go.
Your shoulder. Juror number 7, those are your true and correct verdicts? Juror 7?
Yes.
Juror 8?
Yes.
9 and 10? Juror 9?
Yes.
Juror 10?
Yes.
11 and 12.
Yeah, me too, Kelbell.
Juror 11?
Yes.
Juror 12?
Yes.
All right, all jurors have stated that the verdict forms reflect their individual true and correct verdicts. Alex, read the verdict.
Yes, Your Honor. The Los Angeles Superior Court, County of Los Angeles. People of the State of California versus Joaquin Mayers. Case number BA 508142-01. We, the jury in the above entitled action, find the defendant, Joaquin Mayers,
Look at him breathing.
not guilty of the
There it is. Yeah, he was breathing hard.
Now get the audience. Or you can now get the audience.
Hold it down, hold it down. The verdict has to be read on camera.
Repeat again, we, the jury.
Judge Arnold was probably over there smiling.
Joaquin Mayers, not guilty of the semi-automatic firearm in violation of Penal Code Section 245, Section B, a felony. It's charging count 1 of the information this 18th day of February 2025, jury seat number 9, 4 person.
All right.
Title of court and cause. We, the jury, in the above entitled action, find the defendant, Joaquin Mayers, not guilty of the crime of assault with a firearm in violation of Penal Code Section 245,
man.
Section B, a felony of charging count 2 of the information this 18th day of February 2025, juror seat number 9, 4 person.
Joe looked at the jury and said, thank you, man. Hey, that's a great moment. Congratulations to Rocky. Hopefully he uses this for good, because this is definitely a second chance. I know we had talked about it. A lot of us were thinking this could go one or two ways. I had a strong feeling it was going to be not guilty, and I'm glad that is the case. Now, moving forward, Rocky is not done. He's not out of the woods yet. And I want to go through some of these pending legal issues that he has going on. Obviously, we know they're between him and ASAP Relli. I think we're just going to call him Relli from now on, because I have a feeling the ASAP is not going to be connected anymore. So the first thing we have is, initially, as we talked about in previous videos, Relli filed 2 lawsuits. Obviously, the lawsuit that was attached to the assault, which in this case, I don't know how that moves forward, especially since he's been found not guilty of the assault on both counts. And then the second one is the defamation case, which is a little bit more lengthy. That one's 39 pages, and it goes into detail about what Joe Tacopina was saying leading up to the trial, throughout the trial. And I'm going to be honest, we may see another amended complaint based on the interviews that Joe Tacopina did after this trial. We'll have to let Camille handle that one. I don't know how they're going to handle that moving forward. So they filed that defamation lawsuit, and then obviously it was up to Joe Tacopina Law Firm, and of course ASAP Rocky, who are all mentioned as defendants in this claim, to respond. So let's look at a couple of their responses here. So here's their first response to the defamation lawsuit, and let's see what they say. Defendant Joaquin Mayers, answering defendant, hereby answers the complaint of plaintiff Terrell Efron, we're just going to call him Relli, make it easier, as set forth below. General denial. Pursuant to California Code of Civil Procedures 43130, answering defendant generally denies each and every allegation of complaint and specifically denies the plaintiff has been damaged in any amount or in any way as a result of any actions or omission of answering the defendant. Okay. First affirmative defense. What are they saying? They're talking about the injuries, exclusive fault of third parties. The injuries and or damages complained of in the complaint, if any, were caused solely, directly, and proximately by the negligent or intentional actions or omissions of persons other than answering the defendant. Basically saying, hey, we didn't do it. All right. We didn't do it. Second affirmative defense. Partial fault of third parties. The negligent and or intentional acts and omissions of third parties contributed to the damages complained of in the complaint, if any. Answering defendant is entitled to a judicial determination of the proportion of fault to those third parties and to a reduction of damages, if any, awarded in proportion to this fault. And then third, what do we have? Comparative fault or, oh man, I'm going to mess this up. If plaintiff sustain any injuries and or is entitled to damages under the circumstances alleged in the complaint or in any other respect, and said injuries or damages are wholly or in part directly and approximately caused by the plaintiff's own negligence, lack of due care and or fault of that or the plaintiff agents or employees. In the event that the plaintiff is found to have sustained injury and or to be entitled to recovery of damages, the plaintiff's recovery against answering defendant, if any, must be reduced by the proportion of damages caused by the acts and conduct of the plaintiff and the plaintiff's agents and or employees. All right. Also, they have the failure to mitigate damages as the fourth affirmative defense. The plaintiff failed to mitigate damages, if any, which Relli has sustained and has failed to exercise reasonable care to avoid the consequences of harm, if any, in that, among other things, the plaintiff has failed to use reasonable diligence in caring for any injuries, damages, or property, failed to use reasonable means to prevent aggravation, there we go, of any injuries, damages, or property, failed to take reasonable precautions to reduce any injuries, damages, or property, failed to make any reasonable expenditures which could have been prevented the loss alleged, and otherwise failed to prevent the existence or extent of damage. Also, we have the additional defense, and here's what they're looking for. Wherefore, answering the defendant, the praise for judgment as to the plaintiff's complaint as follows. The plaintiff take nothing and obtain nothing by virtue of the complaint. Dang! The plaintiff take for cost incurred herein and for such other and further relief as the court may deem just or proper. And then that was signed by, of course, the attorneys for Rakeem Mayers, aka ASAP Rocky. We've got Robert Shapiro, Sean Riley, and James Sargent. All right, so that's the initial one. Then we have Rocky's answer to the defamation lawsuit. So this one's going to get actually pretty interesting, and it kind of is going to say the same thing, but let's see what they're talking about in this one. ASAP Rocky hereby answers the unverified first amended complaint of the plaintiff, Relli, dated on September 19th, 2023, or they're going to call it the FAC moving forward. And then they have a general denial, right? Pursuant to California Code of Civil Procedures 431, defendant generally and specifically denies each and every allegation of the complaint and each and every cause of action contained therein, and further specifically denies the plaintiff has been damaged in any amount or in any way as a result of any action of omission from the defendant. Basically saying in the defamation lawsuit, it's basically saying Rocky didn't do anything himself because Rocky hasn't really been speaking out about it. But Joe Tacopina, which was representing ASAP Rocky in this criminal trial, has been saying a lot in representation of Rocky, which is therefore Rocky saying it, right? So we know Joe, he's going to do his thing on this one. And I have a feeling he's going to fight this to the end. We'll have to wait and see. All right. What do they say? Failure to state a cause of action. The complaint and every and each and every purported cause of action therein against the defendant fails to state facts sufficient to constitute a cause of action or state a claim upon which relief can be granted. All right, their First Amendment, the complaint in each and every purported cause of action therein gives rise to no viable cause of action against the defendant. And as any statements defendant made regarding the plaintiff are protected by the First Amendment of the United States Constitution. Basically, he can go out there and say how he feels. Joe can say how he feels about the defense and their case in this criminal case being brought forward. That's not defamation. Interesting. What is the third? The truth. I have not seen this before in a response, but I love this. They said the truth. That is amazing. The complaint in each and every purported cause of action therein gives rise to no viable cause of action against the defendant. And any statements defendant made regarding the plaintiff were either true or made without the requisite degree of fault to trigger liability. And again, this is where the criminal trial could come into play. You have a prosecutor who clearly doesn't, oh man, I don't want to say this. In this case, I'll say clearly didn't care about the truth, didn't care about justice. He just cared about making sure they got a win. So much so that John Lewin was willing to go up there in front of a jury and say, hey guys, I know this man lied on the stand. Put that aside. Let's look at what actually happened, which is insane. Now we're going to the truth and saying that this same man is telling the truth in this civil lawsuit when he repeatedly lied on the stand and Rocky was found not guilty. I mean, stop the cap. Not a great look. No false statements, no false statement of fact. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the statements alleged to be defamatory are not false statements of fact. I mean, think about it. Think about it. Joe said that Relli was trying to extort Rocky and Relli was a liar. With Rocky getting this not guilty verdict, does that prove Joe's previous statements were true? Because Joe can now say, hey, listen, I said all these things about Relli. Look what happened on the stand. He lied. A jury found him not guilty. Why? Because Relli lied about what happened. You see the video, you see the scrapes on his hand. Everything I said about this man is true, and he's just trying to get a payday. He's not a victim. Dang. Statements of opinion. Here's the other part. It goes to the First Amendment as well. The complaint does not state facts sufficient to constitute a cause of action against the defendants in that the statements alleged to be defamatory are expressions of opinion. 6. Constitutionally protected speech. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the alleged defamatory statements of which plaintiff complains are related to a matter of public concern and thus are constitutionally protected by application of Code of Civil Procedure 425-16. There's no injury. Oh man, they said this boy's capping again. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the statements alleged relate to a matter of public concern and plaintiff failed to adequately allege that those statements concerning him caused the plaintiff any actual injury. His career was already over. That's tough. They said it can't be defamation if you don't have a career. Dang. Lack of knowledge of falsity. The complaint does not state facts sufficient to constitute a cause of action against the defendant as it fails to allege that the defendant broadcast the alleged defamatory statements with knowledge of their falsity or with reckless disregard for their truth. And again, I'm going to keep saying this. As we've seen in this criminal trial, everything that Joe said was proven to be true. And the jury backs him up there. We saw all the evidence in court. We saw John Lewin said, hey, this guy lied. It's fine. What else do you need? Privilege. The complaint and each purported cause of action alleged against the defendant gives rise to no viable theory of recovery against the defendant as the alleged statements are privileged by application of Civil Code 47C. There is also no oppression, fraud, or malice. Defendant alleges that the plaintiff is not entitled to recover punitive damages because he has failed to plead and cannot prove facts sufficient to support allegations of oppression, fraud, and or malice as required by California Civil Code 3294. Further, defendant committed no oppressive, fraudulent, or malicious acts with respect to the plaintiff, did not engage in this despicable conduct with respect to this plaintiff, nor did the defendant authorize or ratify any such acts. Again, Joe was just out there doing interviews and giving his opinions and his thoughts. Totally allowed, totally legal. That's what they're saying. Punitive damages violate the procedural and substantive due process. We're going to skip over that. We're going to skip over waiver. We're going to skip over this part. We'll go to the statute of limitations. This is interesting. The complaint and each purported cause of action therein is barred, and relief cannot be obtained based on any and all applicable statutes of limitation. I wish they would list what those are. And then they reserve additional defenses. We'll read that there. And then wherefore the defendant prays for judgment as to the plaintiff's first amended complaint as follows. The plaintiff take nothing and obtain nothing by virtue of the first amended complaint, the plaintiff's first amended complaint, and this action be dismissed in its entirety and with prejudice. That judgment be entered in favor of the defendant on all claims, that the defendant recover his cost of suit incurred herein, as well as attorney's fees to the extent permitted by law, and for such other and further relief as the court may deem proper, and that's signed again by ASAP Rocky's attorneys. And then they're showing that they served this via email, which is always interesting. And we have one more thing I want to get into, but before we get into this last piece, which is Relli's response to what Joe had to say on this one, I want to know what y'all think about this and just the civil suit in general. If you were to take a second and look at all of the quote unquote evidence that was presented during the criminal trial, if you haven't seen it, go make sure you check out the videos and check out the ASAP Rocky trial playlist so you can see what actually went on throughout the trial. Let me know how y'all are feeling about the civil case. Looking at it from a civil aspect, do you think this is something that could go through regardless of what the criminal case showed? Because in the civil case, as I mentioned before, and I want to make sure I read this, the burden of proof is just a preponderance of evidence, right? So it doesn't have to be like it is in a criminal case. It doesn't really focus on reasonable doubt. Is there a preponderance of the evidence? Meaning, is that possible? Is it likely that that happened? When it comes to defamation, I don't know. This might be a tough one. And basically, do y'all believe it's more likely to be true? That's something you have to ask yourself as well. All right, then we have this. What do we have by Relli over here? He says the plaintiff Relli's opposition to defendant ASAP Rocky's motion to stay civil action pending criminal proceedings. So basically, they wanted to hold off. They went through a whole thing. Joe had a back and forth basically saying the only reason the criminal trial was in place in the first place is to help out Relli's civil lawsuit. And there was a lot of threats there. I'm actually not going to get into this one, but I'll leave the link to this full document below. Let me know what y'all think in the comments and in the chat.